Hello there, Steve here. Welcome back to another Sleepy Steve story. I hope you are tucked in, comfortable, and warm. Go on. Adjust your pillow if you need to. Let your shoulders drop, and allow the day to slow down around you, because there is absolutely no rush tonight. None at all. Before we drift off tonight, remember to subscribe to help Steve-O out, and I will keep making more sleepy stories to help you study gently, revise quietly, and settle your mind at the end of the day. We are exploring VCE Legal Studies, Unit 3, Area of Study 1, and tonight we are focusing on criminal pretrial procedures in the Victorian criminal justice system. We are going to move gently through the steps that may happen before a criminal trial begins, including police investigation, arrest and charge, bail and remand, committal proceedings, plea negotiations, and the way these procedures can support or sometimes limit the principles of justice, fairness, equality, and access. You do not need to write these down right now. You do not need to hold every definition tightly. Just let the ideas drift through your mind in order, like quiet railway stations passing outside a dark window, each one glowing for a moment before the train moves slowly onward. Take a slow breath in now, and let it go. Let your hands rest. Let your eyes become heavy if they want to. And imagine that we are sitting in a quiet study room late at night with a lamp glowing softly on the desk, a notebook open in front of us, and rain tapping gently against the window while the rest of the house has settled into silence. The first thing to remember is that a criminal trial does not appear suddenly, fully formed, like a door opening at the end of a corridor. Before a trial begins, there may be many careful steps, and those steps matter because the criminal justice system has serious work to do. It must determine whether an accused person is guilty of an offense. It must protect the community. It must recognize the rights of the accused. It must recognize the interests and rights of victims. And it must do all of this in a way that aims to achieve fairness, equality, and access. Pre-trial procedures are the processes that occur before a trial, or before a matter is finally resolved. And although every case is different, these procedures can help prepare the case, clarify the issues, test the strength of evidence, encourage early resolution where appropriate, and reduce unnecessary delay. They are not just technical steps. They are part of the structure that helps the system work. And because we are studying Unit 3, we are not only asking what each procedure is, but also asking whether it helps the criminal justice system achieve the principles of justice. Fairness asks whether the process is impartial, whether people have a reasonable opportunity to present their case, and whether decisions are made according to law and evidence. Equality asks whether people are treated equally before the law, and whether differences in resources, language, age, disability, culture, legal knowledge, or personal circumstances create unfair disadvantage. Access asks whether people can understand and use the legal system, whether they can obtain advice, whether they can participate meaningfully, and whether barriers like cost, delay, complexity, and stress make the system harder to use. So tonight, as the rain continues softly outside the window, we will walk through each pre-trial procedure slowly, and we will keep returning to those three words: fairness, equality, access. Let's begin with investigation. A criminal matter often begins when police become aware that an offense may have occurred. This might happen because a person reports a crime, because police observe something directly, because evidence is found, because a witness provides information, or because an ongoing investigation leads police to suspect that a particular person may have committed an offense. The purpose of investigation is to gather evidence, and evidence is the material that may later be used to support or challenge the case. Police may speak to witnesses, collect physical evidence, examine digital material, take statements, review footage, prepare reports, and try to establish what happened, who was involved, and whether there is enough evidence to justify further action. At this early stage, it is very important to remember the presumption of innocence. A suspect is not guilty simply because they are being investigated. A person is not guilty simply because police ask questions. A person is not guilty simply because others believe they may have been involved. The prosecution must still prove guilt beyond reasonable doubt. And that standard remains high because the consequences of a criminal conviction can be very serious. Police have significant powers, but those powers do not exist without limits, because a system that gives police power must also protect individual rights. Police may have powers to question, search, arrest, take fingerprints in some circumstances, gather evidence, and apply for warrants. But those powers should be exercised according to law, and where they are not, the fairness of the process may be challenged. For example, if evidence is gathered improperly, a court may have to consider whether that evidence should be admitted, and if an accused person is questioned unfairly, denied access to legal advice, or treated in a way that undermines their rights, then the integrity of the process may be affected. So the investigation stage can support fairness by helping gather evidence carefully and lawfully, but it can also raise concerns if power is used unfairly, if a person does not understand their rights, or if unequal access to legal advice affects how well they can respond. Take another slow breath in and gently let it go. The rain continues outside. The lamp on the desk glows softly, and now we move from investigation to arrest and charge. An arrest occurs when a person is taken into custody because police believe there is a lawful basis to do so, and the purpose of arrest may include ensuring the person appears before the court, preventing further offending, preserving evidence, protecting others, or allowing the investigation to continue. After investigation, if police believe there is enough evidence, the person may be charged with an offense. A charge is a formal accusation that a person has committed a criminal offense, but it is still not proof of guilt. This is one of the most important ideas to keep settled in your mind. A charge begins the formal criminal process, but the accused is still presumed innocent. The charge tells the accused what the allegation is. It gives shape to the case. It allows the matter to begin moving through the criminal justice system. But the burden of proof remains on the prosecution, and the standard of proof remains beyond reasonable doubt. The accused does not have to prove innocence. The prosecution must prove guilt. At this point, the accused should understand what they have been charged with, because fairness requires that a person knows the case they are facing. If a person does not understand the charge, if they do not understand the possible consequences, or if they cannot access legal advice, their ability to participate may be reduced, and that can affect fairness, equality, and access. For example, an accused person with strong legal representation may better understand the options available to them. while a person without advice may feel confused, pressured, or unable to make informed choices. This is why access to legal assistance is so important throughout the criminal process, especially before decisions are made that may affect the entire direction of the case. Now, let your breathing slow again. No need to rush the next idea. We are moving to bail and remand. After a person has been charged, the system must decide whether that person should remain in the community while waiting for the matter to continue, or whether they should be held in custody. Bail means that the accused is released from custody while awaiting trial or another court event, usually with conditions attached. Those conditions might require the accused to attend court, live at a particular address, report to police, avoid contact with certain people, stay away from particular places, or obey other restrictions designed to manage risk. Remand means that the accused is held in custody while waiting for the case to proceed. Bail is important because the accused has not yet been found guilty, and because holding a person in custody before guilt is proven can seriously affect their life, their work, their family, their education, their mental health, and their ability to prepare a defense. At the same time, the court must consider the safety of the community, the interests of victims and witnesses, the risk that the accused may not attend court, and the risk that further offending or interference with evidence may occur. So bail involves balance. It balances the presumption of innocence with community protection. It balances the rights of the accused with the interests of victims. It balances liberty with risk. In terms of fairness, bail can help ensure that an accused person is not punished before guilt is proven, and it may help them prepare their case more effectively because they are not doing so from custody. In terms of equality, bail can raise concerns if people with stable housing, money, family support, or legal advice are better able to meet bail conditions than people who are disadvantaged, homeless, isolated, or struggling with mental health or substance use issues. In terms of access, bail decisions can affect a person's ability to meet lawyers, gather documents, speak to support services, and participate in the process. If the accused is remanded, they may face greater practical difficulties in preparing their defense, although remand may be considered necessary where the risks are too high. So when you think about bail and remand, do not just remember the definitions. Remember the tension. Bail protects liberty before guilt is proven. Remand protects the community and the process where release would create unacceptable risks. And the court must carefully weigh those issues according to law. Let's pause here for a moment. Breathe in slowly and breathe out. Let the words settle like rain on glass. Now we move to committal proceedings. Committal proceedings are used in relation to serious indictable offenses, and they take place in the magistrate's court before a matter may proceed to trial in a higher court, such as the county court or the Supreme Court. The purpose of a committal proceeding is not to decide guilt. That is very important. A committal is not the trial. Instead, a committal helps determine whether there is enough evidence to support a conviction by a properly instructed jury at trial, and whether the accused should be committed to stand trial. It is like a careful checkpoint before the case moves further into the system. Committal proceedings can serve several purposes. They can allow the accused to understand the prosecution case. They can help identify the issues in dispute. They can test the strength of the evidence. They can allow some witnesses to be questioned, depending on the rules and permission of the court. They can encourage early resolution if the evidence is strong or if the issues become clearer, and they can help filter out cases that should not proceed to trial because the evidence is insufficient. In this way, committal proceedings may support fairness by ensuring that weak cases do not move unnecessarily to a full trial, and by giving the accused more information about the case they must answer. They may support access by making the issues clearer and reducing uncertainty. They may support equality if both sides are able to properly participate and understand the evidence. But committal proceedings can also create challenges. They can add time. They can increase costs. They can create stress for victims and witnesses, especially if they are required to give evidence or be questioned before the trial. They can be complex, particularly for accused people without strong legal representation. So again, the system is balancing benefits and difficulties. A committal can improve fairness by testing evidence, but it can also contribute to delay and stress. A committal can clarify issues, but it can also make the process longer and more expensive. A committal can protect the accused from facing an unnecessary trial, but it can also be difficult for victims and witnesses who must engage with the system before the trial even begins. When you are revising, try to avoid saying that a procedure is simply good or bad. In VCE legal studies, stronger responses often explain both sides. They explain how a procedure may assist fairness, equality, and access, and how it may also limit them. Now, let the room become quiet again in your imagination. The notebook is still open. The rain has become lighter, and we move to plea negotiations. Plea negotiations are discussions between the prosecution and the accused, usually through their legal representatives, about the possibility of the accused pleading guilty to one or more charges, sometimes in exchange for other charges being withdrawn, or a charge being reduced, or the facts of the case being agreed in a particular way. The purpose of plea negotiations is to resolve the matter without the need for a full trial, where that is appropriate. This can save time. It can reduce costs. It can reduce stress for victims and witnesses because they may not need to give evidence at trial. It can allow the court system to use resources more efficiently, and it can provide the accused with some certainty, especially where there is a possibility of a sentence discount for an early guilty plea. But plea negotiations must be approached carefully. They should not pressure an innocent person to plead guilty simply because they are frightened, tired, confused, disadvantaged, or worried about the risk of a harsher outcome after trial. They should not make the system feel like justice is being traded behind closed doors. They should not ignore victims, who may feel that a negotiated outcome does not fully reflect the seriousness of what happened. So plea negotiations can support access and efficiency by resolving matters earlier, but they can also raise fairness concerns if power imbalances, poor legal advice, emotional pressure, or lack of understanding affect the accused person's decision. They can support victims by avoiding the stress of trial, but they can also cause victims to feel that the full story has not been heard in open court. They can help the system manage its workload, but they must still produce outcomes that are consistent with justice. A useful way to remember plea negotiations is to think of them as a quiet side path. Not every case takes that path. Not every case should take that path. But when it is used properly, it can help a matter reach a lawful resolution without the full length and pressure of a trial. Take a slow breath in and let it go. We are moving gently now towards another related idea: sentence indications. A sentence indication is a statement from the court about the likely sentence that may be imposed if the accused pleads guilty at that stage of the proceedings. The purpose is to help the accused make an informed decision about whether to plead guilty by giving them a clearer understanding of the possible outcome. Sentence indications may encourage early guilty pleas where appropriate, which can save time, reduce costs, reduce delays, and spare victims and witnesses from the stress of a contested trial. They may also support fairness by giving the accused more information before making a serious decision. But again, there can be concerns. If an accused person feels pressured by the indication or does not fully understand the advice they are receiving, there may be fairness issues. If the accused has limited legal support, limited English, cognitive difficulties, or high stress, their ability to make an informed choice may be reduced. So, sentence indications can improve access to information and support early resolution, but they must be managed carefully to avoid unfair pressure. Now, let's gather these procedures together. Investigation gathers evidence. Arrest and charge begin the formal accusation. Bail and remand decide whether the accused remains in the community or in custody while the case continues. Committal proceedings test whether there is enough evidence for a serious indictable matter to proceed to trial. Plea negotiations may resolve the matter without a trial. Sentence indications may help an accused person understand the likely outcome if they plead guilty. Each step has a purpose. Each step can affect fairness. Each step can affect equality. Each step can affect access, and each step reminds us that the criminal justice system is not only about the trial itself, because the road before trial can shape the outcome, the experience of the parties, and the ability of the system to function. Let's now think about delays a little more deeply, because delay is one of the most common issues students can use when evaluating pretrial procedures. Delay can reduce fairness because memories fade, witnesses become unavailable, evidence may become harder to rely on, and accused people and victims may live with uncertainty for a long time. Delay can reduce equality because people with money, strong support, and legal advice may cope better with long proceedings than people who are already disadvantaged. Delay can reduce access because the longer a matter takes, the more stressful, expensive, and confusing the process may become. But some time is necessary. A fair system cannot always be fast. Evidence must be gathered properly. The accused must understand the case. Victims and witnesses must be treated carefully. Lawyers may need time to prepare. Courts must manage many matters. And serious decisions require care. So the issue is not simply whether the system is quick. The issue is whether the time taken is reasonable, useful, and connected to a fair process. Too much speed can become unfair. Too much delay can also become unfair. The balance matters. Now think about costs. Legal representation can be expensive. Expert evidence can be expensive. Court preparation can be expensive. Travel, time away from work, child care, emotional stress, and the practical difficulty of attending court can all add to the burden. Costs can affect access because people may struggle to obtain legal advice or understand their options. Costs can affect equality because people with more resources may be better placed to prepare, challenge evidence, negotiate, and participate effectively. And costs can affect fairness because a person who cannot properly prepare their case may not receive the same practical opportunity to be heard. This is why support services, legal aid, duty lawyers, interpreters, victim support services, and clear court information can matter so much. They do not remove every problem, but they can reduce barriers. They can make the system more understandable. They can help people participate more meaningfully. And they can move the system closer to fairness, equality, and access. Let's breathe again, slowly in and slowly out. Now, before we finish tonight, let's place pre-trial procedures into the broader purpose of the criminal justice system. The criminal justice system is designed to determine whether an accused person is guilty, to impose sanctions where appropriate, to protect the community, to uphold rights, to recognize victims, and to maintain public confidence in the rule of law. Pre-trial procedures help this system by organizing the case before trial. They help clarify what is disputed. They help ensure the prosecution case has enough evidence. They can help encourage appropriate guilty pleas. They can help avoid unnecessary trials. They can help manage risk through bail and remand decisions. And they can help the courts use time and resources more efficiently. But they can also create barriers. They can be slow. They can be expensive. They can be stressful. They can be confusing. They can affect victims, witnesses, and accused people differently. They can advantage those with stronger legal representation, and they can make the road to trial feel long and difficult. So when we evaluate them, we need calm, balanced thinking. Not simply, this procedure is good. Not simply, this procedure is bad. Instead, we ask, what is its purpose? How does it help the system? And what problems may it create for fairness, equality, and access? That is the kind of thinking that helps in Unit 3. Now the rain outside has almost stopped. The room is quiet. The notebook can close soon. And we can gently recap the ideas from tonight. Pre-trial procedures occur before a criminal trial or before a matter is otherwise resolved. Investigation allows police to gather evidence and determine whether further action should be taken. Arrest and charge move a matter into the formal criminal process, but they do not remove the presumption of innocence. Bail allows an accused person to remain in the community while awaiting the next stage, often with conditions, while remand means the accused is held in custody before the case is resolved. Committal proceedings are used for serious indictable offenses to test whether there is enough evidence for the accused to stand trial in a higher court. And they can clarify issues, test evidence, and filter cases, although they may also add delay, cost, and stress. Plea negotiations involve discussions between the prosecution and defense about a possible guilty plea, and they can save time and resources, but they must not pressure people unfairly or undermine confidence in justice. Sentence indications can help an accused person make an informed decision about pleading guilty by indicating the likely sentence, but they must be used carefully because the decision to plead guilty is serious. And through all of these procedures, we keep returning to the principles of justice: fairness, equality, access. Fairness asks whether the procedure gives people a proper opportunity to understand and participate. Equality asks whether people are treated without unfair disadvantage. Access asks whether people can actually use the system and receive the help they need. You have done enough now. You do not need to repeat the words again. You do not need to hold them tightly. Let the ideas rest gently in your mind. Investigation, charge, bail, remand, committal, plea negotiations, sentence indications, fairness, equality, access. The steps before trial are like quiet stations along a line, each one helping the case move forward, each one carrying its own purpose, and each one reminding us that justice is not only about where the case ends, but how carefully it travels there. Let your breathing slow. Let your shoulders soften. Let the room become still. Your studying is done for tonight. This has been Sleepy Steve, helping you fall asleep and study. Rest easy and sleep well. Good night.